Forum Romanum is loud with argument. It is early morning. The sun has only just begun to slide between the columns of the basilicas, and already a crowd has gathered before the tribunal. Two men stand at the center of the commotion. One claims that a strip of farmland on the edge of the Tiber belongs to him by right of inheritance. The other insists that he has cultivated it openly for years and that possession has ripened into ownership. Around them are merchants, senators, freedmen, and slaves. All wait to hear what the magistrate will say. The decision will not be arbitrary. It will not depend on the magistrate's mood or on the social standing of the litigants, at least not openly. It will rest on rules, carefully articulated, debated, and refined rules. Rules about property, possession, inheritance, and evidence. Rules that have been developing for centuries. And in ways both visible and invisible, those rules are still shaping your life. When we speak of Roman law, we are not referring merely to an ancient curiosity, a relic confined to textbooks and museum inscriptions. We are speaking of a system so durable, so intellectually coherent, that it became the skeleton of European legal culture, and through it, much of the modern world. Concepts you encounter when you sign a contract, inherit property, form a corporation, or invoke a legal right often trace their lineage back to that noisy morning in the Forum. But how did this come to be? Why did Roman law, among all the legal systems of antiquity, prove so enduring? The answer begins not with grandeur, but with crisis. In the early Roman Republic, law was not a published code accessible to all. It was a guarded tradition, monopolized by a small elite of patrician families. Legal knowledge meant power. To know the correct ritual phrases for a lawsuit, the proper day to bring an action, or the precise form of a contract, was to hold leverage over one's fellow citizens. Plebeians, excluded from this knowledge, grew restless. In the 5th century BCE, amid social tensions that threatened the stability of the young republic, they demanded transparency. The result was the creation of the 12 Tables, Rome's first public codification of law. The 12 tables were engraved and displayed in the Forum. For the first time, ordinary citizens could see the rules that governed them. The content was often harsh by modern standards. Debtors could be enslaved, penalties were severe, but the principle was revolutionary. Law was no longer secret custom. It was public, fixed, and, at least in theory, binding on all. That idea, that law stands above individuals and must be publicly knowable, remains one of Rome's most profound gifts. Over time, Roman law grew far beyond those early bronze tablets. As Rome expanded across Italy and then the Mediterranean, it encountered new peoples, new commercial realities, and new complexities. The old rigid forms proved inadequate. Roman jurists, legal scholars of remarkable intellectual discipline, began to adapt the system. One of their most significant innovations was the development of the ius gentium, the law of nations. This was not international law in the modern sense. Rather, it was a body of principles thought to be common to all civilized peoples, particularly in matters of trade and contract. As Roman merchants did business with Greeks, Phoenicians, Egyptians, and Gauls, practical necessity demanded flexibility. Out of this practical need emerged a strikingly modern concept. That law could be derived from reason. Roman jurists such as Gaius and later Ulpian and Papinian did not simply memorize statutes. They analyzed, they categorized, they asked, what is ownership? What is possession? What is an obligation? What makes an agreement binding? They distinguished between real rights and personal rights, between public law and private law, between civil law and the more universal principles applicable to foreigners. Consider for a moment the contract you may have signed recently, perhaps a lease, an employment agreement, or a loan. The idea that a contract is formed through mutual consent, that obligations arise from agreement rather than ritual incantation, was refined in Rome. Earlier Roman law required precise formalities, but by the late Republic and early Empire, a more flexible understanding prevailed. Consensus itself could create binding obligation. This shift was profound. It recognized individuals as rational actors capable of shaping their own legal relationships. Modern contract law across much of Europe and in legal systems influenced by it still reflects this Roman foundation. The same is true of property. Roman law distinguished carefully between possession and ownership. Possession was a matter of physical control and intent. Ownership, dominium, was a deeper, legally recognized right. The difference mattered. A person might possess something without owning it. Another might own it without possessing it. From these distinctions grew doctrines about adverse possession, usufruct, servitudes, and easements. If you own a home, if you inherit land, if you grant someone the right to use your property without transferring ownership, you are operating within conceptual categories Rome helped articulate with precision. Yet Roman law was not static. It evolved through a dynamic interaction between magistrates and jurists. Each year, a praetor, a judicial magistrate, issued an edict announcing how he intended to administer justice. While bound by tradition, the praetor could introduce new remedies, recognize new forms of action, and adapt the law to changing circumstances. Over time, these edicts accumulated, forming what became known as the Praetorian Law. This interplay between stability and innovation is another Roman legacy. Law was not immutable. It could respond to equity and fairness. If rigid application of an old rule produced injustice, the praetor might craft a remedy. Modern legal systems, particularly those in the civil law tradition, still reflect this balance between codified stability and judicial interpretation. But perhaps the most consequential moment in the history of Roman law came not in the Republic, nor even at the height of imperial power, but in the 6th century CE, under the Emperor Justinian. By that time, the Western Roman Empire had fallen. In Italy, Germanic kingdoms ruled. In the Eastern Mediterranean, however, the Roman Empire, what we now call the Byzantine Empire, endured. Justinian, ruling from Constantinople, sought not only to reconquer lost territories, but to restore Roman greatness in law. The legal tradition had become vast and unwieldy. Centuries of statutes, juristic opinions, and imperial decrees lay scattered and sometimes contradictory. Justinian ordered a comprehensive compilation. The result was the Corpus Juris Civilis, the body of civil law. It consisted of the Code, collecting imperial enactments, the Digest, preserving and organizing the writings of classical jurists, the Institutes, a textbook for students, and later, the Novels, new laws issued during Justinian's reign. This compilation did not merely preserve Roman law, it systematized it. It distilled centuries of reasoning into a coherent structure. For a time, its influence seemed limited. Western Europe, fragmented and politically unstable, had other concerns. But in the 11th century, in the city of Bologna, scholars rediscovered Justinian's Digest. They began to study it intensely, treating it as an authoritative source of rational law. From Bologna, the revival spread. Universities across Europe incorporated Roman law into their curricula. It became the common legal language of scholars and administrators from Spain to Germany. In many regions, local customary law continued to operate. But Roman law provided a framework, a rational system that could fill gaps, resolve ambiguities, and offer intellectual coherence. In the Holy Roman Empire, it was received as a subsidiary law. In France, it deeply influenced the eventual Napoleonic Code. In Germany, it shaped the Bürgerliches Gesetzbuch. Across continental Europe, Roman categories became embedded in national codes. Even in countries that developed the common law tradition, such as England, Roman influence was not absent. Ecclesiastical courts drew heavily on Roman principles. Concepts of equity, trust, and certain contractual doctrines reflect indirect Roman heritage. When you hear terms like civil law, obligation, testament, corporation, or guardian, you are often hearing Latin echoes. And there is something else, perhaps even more fundamental. Roman law advanced the idea that individuals possess certain legal capacities by virtue of their status. True, Roman society was deeply hierarchical. Slaves had no legal personhood. Women's legal capacities were limited. Citizenship conferred immense privilege. Yet over time, the category of Roman citizenship expanded dramatically. In 212 CE, the Emperor Caracalla granted citizenship to nearly all free inhabitants of the empire. This universalization did not create modern human rights, but it did help normalize the notion that law applies across vast, diverse populations. It accustomed societies to thinking in terms of general legal categories, rather than tribal or purely local custom. The Roman jurists also developed a concept of natural law, ius naturae, grounded in reason and common to humanity. While they did not articulate modern rights discourse, their language influenced later Christian theologians and Enlightenment thinkers. Through this intellectual lineage, Roman legal thought contributed to the eventual emergence of modern ideas about equality before the law. It is important not to romanticize. Roman law operated within an empire sustained by conquest and slavery. Legal protection varied according to status. Power often bent rules in practice. Yet the conceptual architecture, the insistence on definition, classification, and logical coherence, proved astonishingly resilient. Why did Roman law endure where other ancient systems faded? Part of the answer lies in Rome's political longevity. The Republic and Empire together spanned over a millennium. Such duration allowed legal institutions to mature. Part lies in Rome's administrative genius. As the empire expanded, it required mechanisms to govern distant provinces. Law became a tool of integration. Granting legal rights and standardized procedures fostered stability. But perhaps most crucial was the intellectual culture of the jurists. They treated law as a discipline worthy of rigorous analysis. They wrote commentaries, debated interpretations, and sought internal consistency. Their writings were not merely practical manuals, they were works of legal philosophy. This intellectual seriousness made Roman law portable. It could be taught, studied, and adapted long after the political structures that created it had vanished. Consider once more that dispute in the Forum. The magistrate, after hearing arguments, rules that the land belongs to the man who inherited it, but recognizes that the other may claim compensation for improvements made in good faith. The crowd murmurs. The decision is not perfect. It satisfies some, disappoints others, but it rests on articulated principles. The idea that disputes should be resolved through publicly reasoned rules, rather than private vengeance or arbitrary command, is not uniquely Roman. Yet Rome gave that idea a durable institutional form. Today, when a judge writes an opinion citing precedent, when legislators draft statutes within established categories, when lawyers argue about interpretation, they participate, whether they realize it or not, in a tradition shaped profoundly by Roman thought. Even the very structure of legal education in many countries, dividing law into property, obligations, family, and succession, mirrors the organizational scheme of Justinian's institutes. There is a certain irony in this legacy. The Roman Empire fell, its cities declined, its western provinces fragmented into successor kingdoms. Yet the legal ideas forged in its courts and classrooms survived the collapse of its political power. Empires rise and fall, laws endure. As we step back from the Forum and allow the noise to fade, we see more clearly what Rome achieved. It constructed not merely roads and aqueducts, but an intellectual framework for organizing human relationships. It sought to tame conflict with categories, to replace uncertainty with definition, to mediate power with procedure. History is not inevitable. Roman law might have remained a local tradition, buried in manuscripts, forgotten in monastic libraries. The revival at Bologna might not have occurred. European states might have developed entirely different legal architectures, but they did not. Instead, through centuries of transmission, adaptation, and reinterpretation, Roman law became woven into the fabric of modern life. When you draft a will, you echo Roman testaments. When you form a company, you stand in a lineage that stretches back to Roman notions of collective legal personality. When you rely on the enforceability of a contract, you trust in principles refined by jurists who lived under emperors long dead. You may never set foot in the forum. You may never read the digest. Yet the intellectual order that structures your legal world bears the imprint of Rome. And that is why, on a quiet morning nearly 2,000 years ago, as a magistrate weighed the fate of a modest strip of farmland, something far larger was at work. Not merely the resolution of a private dispute, but the gradual construction of a legal civilization whose influence would outlast the empire itself. The stones of the forum are worn now. The voices have long since fallen silent. But the reasoning that once echoed between those columns still reverberates. In courtrooms, in contracts, in the very assumptions we carry about rights, duties, and justice. Roman law does not belong only to the past. It lives, quietly and persistently, in the structures that govern our present.